Hi, this is Ken Jabber with the second video in what I call the Ending Your Debt Nightmare video series. This video series is also a rollout of a whole new approach my site is going to take that's going to increase the value that visitors and customers of my site get. You probably remember that in our first video we went through the debt collection process from the beginning where the bills started piling up all the way through to the point where you got sued and you had to decide whether to respond or not and how. And we did that because even if you're already getting sued, this process started long before that. It starts when you first miss a bill payment. The debt collectors begin to prepare. And so when we look at the process, even if you're already being sued, it helps if you know kind of where the cards lie. Okay, in this video we're going to take a quick step back and I want to talk to you about a couple of really fundamental concepts in the law and debt law and negotiation in particular. And then we're going to move on and talk to you about a guy named Frank, who's started as a customer and become a friend of mine, really. In Arizona, he's actually got kind of two case studies because he was sued by two different debt collectors. And he did things that you could do, and we're going to talk a little bit about what happened in his cases and what he thinks about those. Okay, so now we're going to talk about the law, and for that we're going to switch to a slide format.
You may have heard that most civil, that is, not criminal, cases end up not going to trial. Most of them get settled, and there's obviously different kinds of settlement. Why do some cases settle for just pennies on the dollar the plaintiff is suing for, while others settle for just about full price? Or to put it differently, why do you think that people who fight back against the debt collectors often either make them go away or settle for just a token amount, while most people settle for much or even everything the debt collector sued for? Why do you think that is? There are lots of things I don't really know about the way the debt collectors make their decisions, and each decision is made individually between lawyers and parties, so the reasons could be different. But I do know some things based on my experience representing people getting sued and on my many, many conversations with people through my site over the course of 6 years. I know that in almost every case where you defend yourself, the debt collector will take less money, starting almost immediately. If you file an answer, they might knock 20% off right there. If you file some discovery, interrogatories, and requests for documents, they'll probably knock off 30%. I mean, there'd be some talking, but they'd probably take that deal if you offered it, and they might make it themselves. Not saying that you want to take the deal, just showing you how things work. And it gets better the longer you fight. Why? Why does it work that way? Why does your case become so much less valuable to them as soon as you resist a bit? Because all law is a business, or at least all debt law is. They want to make money. They want to make a certain amount of money per dollar invested in the debts they buy and a certain amount per hour of attorney time they spend. That makes sense, right? They don't care about whether you pay, and they really don't care about whether you owe the money. At the end of the day, they want to go home with a profit, and that's all they care about. And they just can't do that if you keep fighting them. Lawyers and debt collectors take risk into account, and we'll talk about that some more too in a while. But for now, if you'll think back on the flowchart of the debt process in the first video and how I urged you to control the flow of information, and really just to cut it off, to be frank, the idea was to increase the uncertainty in the minds of the debt collector, because uncertainty itself is a kind of risk, the kind that drives you crazy when you're trying to run a business and make money. So here's a little secret you might forget. The lawyers that are expensive for you are also expensive for them. They'd rather you didn't think about that too hard, but we're going to in a little while. There's an old saying in the law that goes like this: all negotiations are conducted in the shadow of the law. That means that even though almost every case will settle without going to trial, the parties negotiate. They decide what they will give or take in comparison to what they think would happen if the case did go to trial. When the debt collectors file suit in the first place, they think they're going to win. If you file an answer, they still think they're going to win. And when you file discovery, they still think they're going to win. But they start to think it's going to be a lot of trouble for them. A lot of them will let it go then. But if not, they're going to let it go when and if you really make them think they could lose.
Debt law cases are an unusual kind of law. It's not unusual in lawsuits to have someone with more money suing someone with less money. That happens pretty much all the time, right? But in debt law cases, you almost always involve somebody with the debt collector who's relatively wealthy versus someone who's being sued for debt who tends to have a lot less money. And so there's some advantages that the debt collectors have in this. They always have lawyers. Their lawyers have a lot of practice on these cases and associations. They have some advantages in terms of knowledge. Secondly, these cases for the debt collectors are just all in a day's work. They're going to win and they're going to get some money, or they're going to lose, and tomorrow's a new day for them. Whereas for you, these cases could change your lifestyle. They have a big impact they have much different impact on the person being sued than they have on the person who is suing them. And so that's a kind of asymmetry that's really very important. It's these asymmetries that my new approach is designed to address. We're going to start now with the asymmetries of knowledge, the advantages in knowledge that the debt collectors have over people being sued for debt.
Asymmetry of knowledge. Familiarity with these cases. These lawyers who are suing you spend all day, every day on cases like this. They have associations with other lawyers who spend all day, every day on it. And they also have associations across the country with other law firms and lawyers who spend their time doing these things, so they know the techniques and things that have worked in these cases. And it's not to say that they have been fair or just or anything like that, but they've usually succeeded one way or the other in increasing the bottom line of the debt collectors. And here's another advantage of doing a lot of that stuff that debt lawyers have. The debt lawyers have what you could call document banks. They file the same petition over and over again. How much time do you suppose they had to spend on yours? None at all. A paralegal or a secretary types a command into a computer, and software generates the lawsuit against you. As easy as that.
And by and large, that's the way the rest of the case is going to go too. If you want to find out what kind of evidence they have against you, you serve discovery on them. Those are requests for information and documents that they have supporting their position. They don't want to admit that they don't have any of those things, so with a few taps of a secretary's finger, you get a page full of objections. And if you've been in one of these cases before, or if you're in one now, you know exactly what I'm talking about. It's outrageous and it's unfair. And we're going to fix it, at least to an extent.
And here's something else. Most lawyers don't spend that much of their time on this kind of the law. Talking about the lawyers you might try to hire. They don't have the kind of network of debt lawyers any more than you do, and maybe less. So even if you get a lawyer, you start with that as a disadvantage. It's the way the game is played. You want to play it, you have to know how to deal with it. And again, the lawyer you go to try to hire has the same disadvantages you do, unless he or she specializes in debt law. It means that the debt collector spends 5 or 10 minutes objecting, and your lawyer spends and charges you for 4 hours to deal with it. That's why people tell me that when they try to get a lawyer to defend them in the case, the lawyer either told them that it'd be cheaper to give up, or they want a retainer of between $1,000 and $5,000, and that's just the beginning. How do you neutralize all these advantages the debt collector starts with? How do you get a document bank and associations to share information with you? We'll get there. But first, let's go back to risk. I said that it was one of our keys in debt defense. What is risk? Risk has 3 component parts. Maybe it will be easier if you think of it as a bet. First, how much does it cost if you lose? Secondly, how much do you win if you win? And third, what are your chances of winning? In a sense, the debt collectors put their money on the table first. They buy debt with your name on it, hire a lawyer, and file suit. And if they lose the case, they lose all of that. And there's a fourth part too. We'll call them transaction costs. That is, after they buy the debt and file the suit, how much does it cost for them to keep after you and keep trying to win the suit against you? Lawyers aren't free, and they're not cheap either. And a straight up bet, all the way the odds stack up are usually pretty clear. Heads I win, tails you win. That gives you a 50% chance of winning, 50% chance of losing, and there's really no cost in flipping the coin. What if you're not talking about a straight bet, though? What if we're talking about the lottery? There you pay $1 for your ticket, and if you win, you can win a bunch. Your chances of winning aren't great, but what you win is pretty sweet, and you only risk $1. The way lotteries work, because more than one person can win, it's possible to win more or less. You can sort of win, and you can buy more than one ticket. Debt collection is more like a straight-up bet for you, where you can lose. But it's more like a lottery for the debt collector. They pay very small amounts of money for a chance to win the lottery against you. If you fight it and they settle, they win a little bit less. If you win, no one really loses. That is, they don't really lose much money. So that's the way the debt law usually works. If they win the lottery, but if you win, they don't really lose. And there is that kind of asymmetry of risk in debt collection. And it's why I always talk about how important it is to have a counterclaim against the debt collectors, if at all possible. It gives them something to lose, and it's your chance at the lottery win. Remember the rest of the transaction costs, too. How much time they spend on the case. They buy the debt for a set amount of money and pay a filing fee to file suit. But the amount of time and money it costs to keep chasing you is variable. It keeps going up the more you fight.
Okay, in the next video we're going to start talking about the great equalizers, because I think that if you get sued by a debt collector, you have a great chance of winning. We're going to talk about why. But for now, I want to move on to talk about a friend of mine now who started as a customer. His name is Frank in Mesa, Arizona. And Frank is unusual in a lot of ways, but the things that he did to protect himself, you could do. And he's sort of two case studies in one, because he got sued by two different debt collectors for a total of about $15,000. I want to talk to you about what he did and how he feels about what happened. Frank started out with one suit against him filed by a debt collector for about $10,000, $7,500 or so for the what they call the principal. That's the original debt that he supposedly owed, plus some interest, plus attorney's fees of about $2,500. So a little bit over $10,000 altogether is what they sued him for in the first case that got sued against him. And he was panicked, of course, by that. Most people are when they get a lawsuit for $10,000 or more against them. But luckily he came to my site, and he created an answer. And as soon as he served his answer and filed it with the court, the debt collectors came, somewhat off of their demands on him, in terms of settling. They were going to settle with him for about, $7,500. That is the amount that he supposedly owed, but no attorney's fees in that case. He didn't take that deal. And instead, he served discovery on them. Those are the requests for information. And of course, he got 3 or 4 pages of objections, really ridiculous objections. And before he could deal with those, they filed what's called a motion for summary judgment. They asked the court to decide that they were going to win the case. So he filed a response to the motion for summary judgment, and he filed a counter motion for summary judgment, claiming that they had violated the Fair Debt Collection Practices Act in a couple of ways. He had a counterclaim against them. And so he filed a counter motion for summary judgment and a motion to compel discovery, to force them to hand over the documents that they hadn't given him in the first place. And then, before any of that got decided, his case went to mediation. That is, another lawyer was supposed to help the two parties find some common ground and settle the case. And the mediator thought that Frank was very well prepared, better than most people, etc., but that he thought that Frank was going to lose the case, and suggested that Frank should give up. Luckily, Frank didn't do that, but he stuck to his guns. And so as they're approaching the court date, still no decision by the judge, and that's not unusual. There had been no decision on the judge, but the parties finally decided to settle the case. They actually continued to negotiate after the mediation. And finally, Frank did settle the case, and he did give him some money. He gave him about $500. He didn't think he was going to lose the case. He thought that he had a good chance to win the case. But there's always risk. And he didn't want to spend, most of the next 2 weeks getting ready for trial. So even though he thought he could probably win the case, he accepted a settlement where he paid some money, provided the debt collector would fix his credit report and take off some of the things that they had said about him. So they agreed to do that, and so Frank got out of a lawsuit against him that was for $10,000 for about $500. That was one of them. Before that actually happened, though, before that finally happened, another company sued Frank on a different debt, and they were suing him for about $5,000 plus whatever their attorney's fees was gonna be. So I don't know what that was, but they were suing him for about $5,000. But he filed a counterclaim against them under the Fair Debt Collection Practices Act, and an answer and discovery on them all at one time. And about a week later, they filed a motion to dismiss the case with prejudice, and so that one just disappeared. And that's not unusual either. So both of these things that Frank went through, the case where they pursued him for a long way before finally basically giving up, and the case where he filed an answer and they immediately caved in, both of those are not unusual. Those are likely, either one of those could happen with you. So now I want to talk to you about what Frank thought about all of this. He wrote to me, and here's what he said. Today I received in the mail an offer of stipulation for dismissal with prejudice, which basically states the plaintiff will dismiss their claims against me if I dismiss my counterclaim. It's a done deal. Your litigation materials were clear, vital, and necessary tools for me to win. All the examples, logic, and powerful arguments presented in your materials helped me beyond belief. I'm eternally grateful and right now quite ecstatic. Your materials are simply the best and finest of their type anywhere for pro se defendants facing lawsuits. Thanks, Ken. Okay, we have two special reports for you today that I want you to download and think about. One is on the bankruptcy process, because most people who are being sued by debt collectors at least think about running into bankruptcy as a way to get away from the problems, at least for a little while. But there are some big things that you ought to consider when you can think about that you may not hear from the bankruptcy lawyers. The other one is on the debt collection process itself. That is, because a lot of people won't respond to a debt lawsuit, and they end up, the collection process starts and they get their wages garnished or their checking accounts raided. Those can have some pretty devastating consequences that I want you to understand. So those are the two reports for today. I hope you download them and use them and that they're valuable for you. And the next video will be out soon.